Well, we are in season 6. This is episode 12, and our topic today, defamation and social media. What users should know. Talk about being topical. You won't want to miss this episode. It is a season finale of the legal landscape, and recent data has shown that social media sites are now more ubiquitous in our societies and are used by more than 2/3 of internet users. Social media sites such as YouTube, TikTok, Twitter, Facebook, Instagram, and others have revolutionized the way in which we think, we view others, and communicate by providing its users with avenues to have conversations, create web content, voice opinions, and share information with anyone else using these platforms in real time. However, the law prescribes certain responsibilities, obligations, which users must adhere to, especially in light of the 2013 Defamation Act, which covers electronic communication. And by the way, electronic communication, by definition under the new act, would include the use of social media platforms. So in that regard, a person may be found liable under the 2013 Defamation Act for things done on social media. And one must now be cautious not to expose themselves to litigation and the payment of monetary damages to compensate an aggrieved person who claims to have been defamed. So our guest to discuss the topic defamation and social media, what users should know, is Paulette Neal, partner and attorney at law at DunnCox Attorneys at Law. Paulette, thank you for joining us.
Thanks for having me, Dion.
Well, Paulette, we have to start off. What constitutes defamation?
So, defamation can generally be defined as the act of publishing a false statements about a third party, which tends to damage or lower the third party's reputation in the minds of ordinary right-thinking members of society. Now, the publication of the statement can take different forms. So, for example, it can be written words or a photograph or words spoken, for example, on an Instagram live or in a video.
Mm-hmm. So what are the consequences, Paulette, of sharing defamatory material on social media?
Now, when defamatory material is shared on social media, there are serious consequences for the publisher of the defamatory material, as well as consequences for the victim of the defamation. Now, consequences for the victim include the victim's reputation being brought into disrepute and the victim suffering embarrassment. The victim of the defamation may suffer loss of income or diminished earning capacity, as based on what is published about the person, others may not want to associate or do business with the victim. Consequently, as well, the victim may require professional help in the form of therapy and incur expenses to cover the cost. Now, on the other hand, the person who publishes the defamatory statement, that person may be required to make a public apology for the publication or to correct the defamatory statement. Additionally, that person could be sued for the tort of defamation and ordered by the court to pay monetary damages to compensate the claimant for the harm he or she sustained. You may also be required to pay the claimant's attorney's costs for bringing the court action. So there are various and serious consequences.
Mm-hmm. But can we start off by asking then, and again, if you're just joining us, we're speaking with Paulette Neal, partner and attorney at law at DunnCox Attorneys at Law. And our topic this afternoon is defamation and social media, what users should know. So let's ask the very important question, Paulette. What are some of the steps to be taken to avoid a defamation suit?
Right. So to avoid a defamation suit, Dion, before making any statement to another person about a third party, especially on social media, one should first seek to verify the information being shared. And the verification should come from credible sources. You should also consider whether the intended statement will cause any reputational harm to the third party. So if you're unable to verify or credibly verify the information, and the information, if it is published, if it is likely to cause harm to a third party, reputational harm, or if you do know for a fact that the information is not true, then you should not make that statement, as you could expose yourself to a claim for defamation.
Okay. So let's say we've exposed and you were sued for defamation. What are some of the likely defenses?
The Defamation Act outlines 3 main defenses to a claim for defamation, but this list is not exhaustive. So the defenses include, firstly, the defense of truth. So it is a complete defense or action for defamation if the defendant can prove that the imputations in the publication were in fact true or not materially different from the truth. Secondly, the defense of fair comment. Now, defense of fair comment is available to all persons who comment fairly on matters which may be said to be the legitimate concern of the public. So if the claim for defamation is on the basis that the publication includes or consists of expression of opinion, a defense of fair comment shall not fail only because the defendant has not proved the truth of every assertion of the facts relied on. Thirdly, there's a defense of innocent dissemination. This defense is one which applies to persons who innocently distribute defamatory material without knowing that the publications are in fact defamatory. The defense is intended to protect persons who are not authors or the first or main publisher of the defamatory statements. For example, news agents, booksellers, and librarians.
Mm-hmm. Is there a time frame to institute the proceedings for defamation in our courts?
Yes, there is a time frame. Under the Defamation Act, a person has up to 2 years from the date the statement is first published on the internet or the date when it is first capable of being viewed or listened through the internet, whichever is later. Mm-hmm. In the case of other defamatory matter, it's within 2 years from the date the defamation or the defamatory matter rather was first published. However, there are circumstances where a person could apply to the court for an order extending the limitation period.
Well, it's a lot to look at, but the defamation and social media, what users should know, is definitely one that everyone should be at least understanding of the basics of. I want to thank you so much for giving us a topic today. Do you have any hashtag Did You Know tidbits for us?
Well, Dion, my Did You Know tidbit today comes in the form of a caution to your listeners. And it says, your words used on social media may have consequences, and the consequences may come with a cost.
Consequences may come with a cost. You heard it from Paulette Neal, partner and attorney at law at DunnCox Attorneys at Law. And we want to thank you so very much for the series. I can't believe today is the last in the series again. Is there any way that someone can get in touch with you if they want to continue asking you questions on this or any other legal queries?
Sure, certainly. I can be contacted by email or by phone, directly at our office at DunnCox.
And do you want to give us the number for DunnCox?
Sure. My office number is 953-6574. Or email address, paulette.neal@DunnCox.com.
All right. So can you just say that again for me, please? I think you popped out a bit.
Paulette.neal@DunnCox.com.
All right. Paulette.neal@DunnCox.com. Thank you so very much. It's always a pleasure being educated by you.
You're welcome, Dion.
Thank you, Paulette. See you next season.
Indeed. Bye.
defamation and social media. We certainly hope we've covered all that you should know here on The Edge 105.1, 105.3 FM.